in the evening you are let off. That happens to them. So the police can today put down a poor man, a man who resists can put down. Just because you are designed protecting the government, you can be set down by using 151 CRPC. Years ago I remember telling that in this country, police became corrupt through prohibition. Prohibition law came and the police became corrupt. And much later, the TADA law came and the police became autocrats. Under old law, prohibition law, you have to just say, you are found with a bottle of liquor. What do you want, wherever it is? They can come and keep a bottle inside your house, and they come and say, we found a bottle here, and people have been arrested. Large number of people have been arrested like that. Large, because they can always do, if somebody has to be thrown out from the house, if the master has to only arrange with the police, put one bottle of liquor there, after police to raid, the man is arrested. That's okay, this kind of thing. So police became corrupt. And we had heard that those days, the Home Minister at that time, I think it was Balaka Desa, he was the Home Minister, and the rumor was, and that was, I would believe that he was to auction NPS to the police officer. We want a particular police officer to call, we want an NPS section, give so much money to him or his people. And then of course, he would get that police station for a period of 3 years. Then the police would transfer somewhere else. The next man would come. This is the kind of thing. This is the kind of administration that we have. When we brought the Constitution in 1950, soon thereafter, A.K. Gopalan was arrested under MISA, Internal Security. Those days, they would only say, you are a communist. That's enough. You are, the moment you are told you are a communist or you are a communist, you are likely to be behind bars. At the Major Internal Security Act. Because being a communist was such a dangerous thing at that time. Of course, America did that. And therefore, we of course easily followed that. And of course, this was challenged in the court of law. And we have a provision, Article 21, right to life and liberty. The law says, your liberty cannot be taken away, excepting in accordance with the procedure established by law. Which means, your liberty has to be taken away, there should be a law, whatever be the law. There should be procedure, whatever be the procedure. Procedure may be good, bad or otherwise, anything, law may be good, irrational law, no, nothing of the kind. That is the British due process of law. In Britain, that's the law. That if an officer has done in accordance with the law, then you can't question that. That's the kind of thing. But the American due process was totally different. Because now we didn't accept that. And when A.K. Gopalan's case came to the Supreme Court, argument related to human rights was advanced. Principle of natural justice was advanced. All other things were argued. But the Supreme Court had nothing doing. Supreme Court said that 1952 case, report of J. Gopalan's case. What the Supreme Court said was that we are not concerned with human rights. We are not concerned with the other. We look into the Constitution. Article 21 says only this. Here is the law. Here is the procedure. You are arrested. That ends the matter. This law held good for nearly 25 years, some 25, 26 years. And then came the Maneka Gandhi's case. Maneka Gandhi's case where for the Supreme Court, for the first time, elaborated the concept of life and liberty. They said life doesn't mean you are limited in thought. Life will include everything that goes with life. Liberty doesn't mean that just according to law. The law has to be just. Law has to be fair. Law has to be reasonable. Procedure also has to be just, fair, and reasonable. And the law is unjust, you have sight of the law. This is the kind. But so today, after 78, we all should have expected there is more regard for due process in this country. But unfortunately today, the concept of due process is being diluted to such an extent today, you find more and more, for example, benign sin. What ground was he arrested? Nothing. What the procedure they followed? Nothing. What was the trial? It was a bogus trial, that kind of thing. And yet, of course, nothing could be done. Went to the court, how many times? High Court would not give, lower court would give, Supreme Court would not give bail initially. Finally, of course, one day the judge had, one of the Supreme Court judges, didn't even wait for the government, didn't even issue notice, state to release on bail. That was exception. Again, when he is convicted, what happens? Again, the court would not. Question is simple. Can this man? The question is one of liberty. The courts do not look at that way. Now, this is because we have brought in laws like TADA, laws like quota, which gives powers to the police to do whatever they like. They have power to confess. That's how torture became routine in this country, all over the country. Torture goes on in every police station, not an exception. And torture is nothing but inflicting pain for the purpose of getting information. Today we have been demanding that there should be a law related to torture, that the international covenant against torture, and yet of course we have signed everything, but we are not doing a law related to torture. So the police think they can do with impunity. Whatever they do, nobody can question. This is exactly what happened, and one of the reasons is today police are made to believe, the courts are made to believe that security of the country, in the name of security, anyone can be detained. You go to the Supreme Court, even today, any other issue of human rights, perhaps you can argue, they will listen to you. Moment the government says, sir, the matter of security, you are shat. Then security means all things. TADA was upheld. No, you have regard to Manaka's case, the TADA law could never have been upheld because it contains all violations of human rights provisions. It contains all things that have been laid down earlier with the power to confess, which is contrary to our whole criminal jurisprudence in this country. Just we said confession, okay, confession need not be done by a police officer, but if a hierarchy officer does, that confession to be looked into. Bail, of course, cannot be given. That was not the law. So all these things were brought, and that was upheld because the question of security.